na 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 na. Bamba. Oh na 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 na. Bamba. Oh na 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 na. Bamba. Oh na 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 na. Dig it up. Oh na 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 na. Dig it up. Oh na 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 na. Bamba. Bamba 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 de. Bamba bamba. Bamba mi de. Bamba 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 mi de. Bamba bamba. Bamba 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 mi de.
Hello, everyone. Welcome again to Home and Away Jamaica, where we connect Jamaica with the diaspora. I'm Robert Taylor of Taylor Law. And with me again today, for those who joined us last week and the week before, is Stacy Salmon. Stacy is a managing partner at Taylor. And we've decided for the next few weeks, to have some interaction with Stacy and get some answers to some of those pressing situations, those particular questions that we've had from many of our viewers. Good morning, Stacy. How are you?
Hi, morning, Robert. I'm good, thank you. How are you?
I'm good. Thanks for joining us again, Stacy. Today, Stacy, we want to speak about one of the questions we've been getting from our viewers, and it has to do with landlord and tenancy arrangements. And one viewer wanted to know where you have a lease in place, let's say a 2-year lease that speaks to giving a specific notice, in this instance, 2 months notice. Lease terminates, lease ends, but the tenant remains in possession. And this viewer wanted to know what are the landlord's rights, and certainly we can discuss also the tenant's rights after the lease has terminated. The landlord now wants to give notice, but isn't quite sure what provisions apply. There's no longer a contractual arrangement by way of this lease. What is the basis for giving notice for eviction of peaceably getting this tenant out?
All right, so once the duration of the lease comes to an end, there's no longer any binding terms as it relates to the landlord and the tenant. So the landlord is within his right to serve a notice to quit on his tenant, giving the tenant at least 30 days notice to vacate the premises. And if the tenant does not vacate, the landlord can pursue a claim in court for recovery of possession.
So what you're saying to us, Stacey, is that although the contract, having expired, provided for 2 months notice, the tenant is now holding over as a monthly tenant. And so the provisions in that agreement as it relates to notice no longer applies. And what the law now provides is that once you're holding over on a monthly tenancy, you must give 1 month's notice. So there's no obligation to provide the term of notice or period of notice that was established in that expired lease.
That's correct. And the legal term is a tenant at will. So once the lease expires and the tenant carries over, he'll effectively become a tenant at will.
How would you advise, and what's the actual process for issuing that notice? What are some of the things you would do, if a client came to you and said, Stacy, I have this situation, I need this tenant out. What steps would you take?
All right, so first we'd need the details of the tenant, name, address, of all the occupants of the premises, so we can prepare the notice to quit, and the description of the property. Once we prepare the notice, we would have our process server serve the notice on the tenant, and service must be personal, meaning that the notice must be served in person on the tenant. And once the notice period, which must not be less than 30 days, once that expires, then our client could make a claim in court for recovery of possession from the tenant.
Now, does the notice speak to any reasons? And are there any statutory reasons that must be complied with?
Right, so the Rent Restriction Act provides for certain reasons that the landlord must give the tenant, and that must be set out in the notice to quit. One of the reasons, one of the most common reasons, is for non-payment of rent.
And so in this instance, would we cite that reason?
Well, if the lease is no longer effective and the tenant tries to pay the landlord the outstanding rent that is due, the landlord, if he accepts the rent that's paid by the tenant, then that reason won't be valid. So he wouldn't have a valid claim if he accepts the payment of rent after the expiration of the lease.
Because then the monthly tenancy could continue into perpetuity, so to speak.
Correct.
So it would then be advisable to use one of the other reasons established under the Rent Restriction Act.
Right. So another reason under the Rent Restriction Act he could possibly state that he requires the premises for his own personal use. That's another common reason given in these types of notices.
Great. So practically speaking, you have issued that notice. You have used, as you said, you've given personal service. I know in our practice, we use a process server, someone who is quite aware of the court rules so that the notice can be valid and properly served.
Right.
Once that happens, and let's say there is no response or positive response on the part of the tenant in terms of vacating the premises, what would you do next?
Right. So once the notice is properly served on the tenant, after the expiration of the 30 days that's stated in the notice, if the tenant refuses to vacate, then the landlord can commence court proceedings against the tenant. Once he obtains the order to, well, sorry, let me rewind a bit. So if the tenant refuses to vacate, the landlord commences suit in court. What's called the commencement documents are served on the tenant for him to appear in court at the date that's set by the court. And then both parties would attend on the date. The judge will hear both sides, and the judge will make his or her order for the tenant to vacate, or for more time to be given to the tenant to find alternative premises. Right.
So what we see then is a court trying to balance, a social issue where historically landlords have been seen as, persons who have the ability to displace persons in possession. And the courts are trying to strike this balance of reasonableness to make sure that this is not an egregious situation and a tenant is being put out, so to speak. But I think, we've seen many tenants know of this and kind of abuse the process. So there's always this concern that this can be a very protracted period. What, in your experience, is generally can someone in this situation of this landlord expect in terms of getting eventual possession?
Right. So in Jamaica, the laws tend to favor the rights of the tenant. So typically, the judge hearing the matter tend to listen to the side of the story of the tenant. For example, if 30 days notice was served and the tenant attends court and he said, he's been searching for other suitable accommodations, he was unable to find one in the requisite 30-day period, the judge may possibly give another 30 days. If that 30 days has expired, the parties could attend court again. And I think at that time, the judge would probably be more favorable to the landlord if it is that the landlord requires the premises for his own personal use. It is a balance, and it's important that once the notice expires, that the landlord commences court proceeding as soon as practicable, because he doesn't want there to be any further delay in getting the tenant out.
And what happens, Stacy, in the uncommon situation where the order is granted and the tenant still does not vacate?
I wouldn't say it's uncommon. We've had about maybe 2 or 3.
I meant to say common, I'm sorry.
Oh, okay. All right. So if the tenant still refuses to vacate after the order to vacate has been handed down by the judge, then the landlord can apply for an order to have the bailiff from the court attend to the premises and forcibly remove the tenant and along with his possessions. And
so one of the things I think of when going through your responses as well, Stacy, is that many landlords must recognize that while they have legal ownership and they are the title holders, when someone is in possession by way of a lease, that ownership is suspended as those rights vest with the tenant. And any unauthorized entry onto premises could deem that landlord a trespasser. And that in of itself creates other issues.
Right, that's correct. But in this situation, the lease has expired. So the terms set out in the document no longer apply.
Okay. Now, let's take another situation in that particular lease where the lease says 2 months notice, the tenant holds over for an additional month. Well, let's not deal with the holding over period. The question was, the tenant is in possession, the lease calls for 2 months notice, there is a 1 month security deposit, but the tenant vacates with only 1 month notice. What's the right of the landlord?
All right, so once the landlord has the security deposit, typically a security deposit amounts to 1 month's rent. So in this situation where the tenant gives 1 month instead of 2 months notice as required under the terms of the lease, the landlord is within his right to retain the security deposit for unpaid rent.
In this instance, the security deposit being 1 month would mean there is still 1 month of unpaid rent. What would the landlord's recourse be?
Well, if rent would still be outstanding for the period of 1 month. So he would have a claim against the tenant for that 1 month period, whatever that sum is, and he can make a claim in court and sue the tenant for the unpaid rent that's owing to him.
Okay, great, thanks. So Stacy, before we wrap up, one of the things that comes to mind, and I'm wondering, you know, some of our viewers may be asking some of these questions. You know, you have 1 month's rent unpaid. Let's say it could be $60,000, $70,000, $100,000, but you could certainly incur more legal fees just simply from court attendances to collect these unpaid sums. Are there alternatives? Are there options open to a landlord outside of retaining an attorney to make this claim to the court or seek recourse?
Well, the claim for recovery of possession in Jamaica is made in the parish court. And the parish court, they're more accommodating to lay persons. So you don't, as a landlord, you wouldn't typically, or I wouldn't say typically, you would not necessarily require the services of an attorney to represent you at that level.
So what you're saying then is that with the parish court, there is accommodation for these types of disputes to be settled at the layperson level. So a landlord having this issue could go to the parish court, the clerk of the court staff is usually very accommodating in assisting with the preparation of any claim or plaint form and assisting in any recovery proceedings.
Correct.
Okay. Stacy, thank you. We're going to keep it very short and concise as we normally try to do. Thanks for coming and sharing with us. So to our viewers, thanks for joining us. Take care, be safe. Home and away, Jamaica. Until next time.
TV, bam bam, on the street, bam.